Hi, Lee Phillips here. Want to talk to you about why you wouldn't use an irrevocable trust for asset protection. Now, you understand that a revocable trust will not give you asset protection because it's revocable, and I get a judgment against you, and I walk into court and I say, Judge, this is a revocable trust, make him revoke it and give it to me. So revocable trust, if it has that word revocable in it, no asset protection. But how about an irrevocable trust? Well, an irrevocable trust actually, I'm going to say, does give you asset protection. But what you don't understand is if you have an irrevocable trust, you have moved the assets into it irrevocably, and you can't get them back. They're not yours. They're gone. The law says that you can't set up an irrevocable trust with your assets and have that trust give you benefit. That would be cheating. If you could set up a trust, move the assets into it, and make it so your creditors couldn't get them, but you had all of the benefit of those assets, that's just cheating, isn't it? So the law basically says you can't do, or you can't set up what is called a self-settled trust. A self-settled trust. It's an irrevocable trust that you set up, you move the assets into it, and then you get the benefit out of it. That's pretty good. Now, if you want to set up an irrevocable trust for your kids or somebody else and move those assets into that trust, as long as it's a spendthrift trust, that means it has a spendthrift provision in it, and we have a YouTube on spendthrift provisions, then the beneficiaries, the kids, their creditors can't get to the trust. Your creditors can't get to the trust because it's not your property anymore. You don't get any benefit out of it. It's gone. Now, there are a couple of exceptions to that. One is what we now call the Asset Protection Trust, the Legacy Trust. Started out in Alaska, so sometimes we call it an Alaskan trust. Basically, a few of the states, there's about a dozen of them now, have decided that you can set up a trust, self-settled trust, move assets into it, and get benefit out of it. And that's not bad, but there are a bunch of provisions. Provided the assets are in the trust at least like 5 years, and then they'll lock down so your creditors can't get them. Now, Utah actually has a 60-day provision if you publish and a bunch of other stuff where you can lock those assets down into the trust. The trust has to be made in that state. Usually the trustee has to be at least a resident of the state, if not a banking institution in the state. And we've got other stuffs, other YouTubes on legacy or these asset protection trusts. By the way, the courts are starting to attack them. I'm not 100% sure they're going to survive because the courts are saying, no. This is really a self-settled trust, isn't it? Alaska did it to get a bunch of assets up in Alaska under the banking industry's management. So they wanted money up there. But generally, that's still, that's a self-settled trust, I think. So when you have an irrevocable trust, you can't get the benefit of it, but you've got to remember, whoever does get the benefit of it, you have given those assets away to them. They've actually clocked on their gift tax issues. That's another story. But when you give it to those beneficiaries, you give it to them. And you do the crummy letter and you do all the rest of this, that, and the other junk so that it qualifies for the annual exclusion. That's the 15 grand, 16 grand, whatever it is this week. It's gone up. I think I started out below $10,000. So that tells you how old I am. At any rate, you're not really going to use an irrevocable trust for asset protection, because you can't get the benefit out of those assets. If you're willing to give the assets away, okay, you can protect them from your creditors, but hey, give them to me. They'll be protected from your creditors too. Forget that irrevocable trust stuff, okay? This is Lee Phillips, hoping